What should you do if a summons for a debt collection lawsuit is taped to your door, or you find it in your mailbox, or somebody leaves it with somebody else at your house? Now, I get this question a lot, probably honestly more than any other question that I get. And you need to learn about what valid service of a summons is. Now, what I'm about to tell you can differ a little bit depending on the state. So you need to look up your state's rules on what service of a summons requires. You'll find that in what's called the rules of civil procedure. Now, your state's rules may be called something a little different, but it's typically the civil procedure rules, and you'll find it there. In the federal rules, for example, you'll be looking at Rule 4. Now, the federal rules won't apply in debt collection cases for the most part, but the federal rules are very similar to what a lot of states have. So, check there, but I'm going to tell you what's most common. Now, in order for a debt collector to sue you, they have to file a complaint with the court, and then they have to serve you with a copy of that complaint and a summons summoning you to court. They have to serve you with those so that you receive adequate notice of the lawsuit. Now, what they usually have to do is personally give those to you. So what's really common is you'll have a process server or a sheriff or a constable. They will come to your house, or they'll come find you, and they will hand you the documents and say, you've been served with this lawsuit. If that happens to you, you've definitely been served, and you now have an obligation to answer within the required time frame. That is, file an answer to the complaint. But there's other ways to serve. Another common way is certified mail. Now, certified mail is a little different than regular mail because you actually have to sign the receipt saying you have received the document. This is really similar to getting personal service because you're actually having a mail person, a mail delivery carrier, or somebody else actually coming, giving you the documents you sign saying you've received them. In most cases, that is adequate service as well. And the reason for the personal service, the process server or the mail person, the reason for that is because there can be verification that you received the documents. Now, what is not valid service in most cases, there obviously are going to be minor exceptions, but I would say 99% of the time, you cannot be adequately served if you find a letter in your mailbox with the summons and complaint, or you find the summons and complaint taped to your door. Because there's no verification that you received it. There's no person that could show up in court if necessary and say, hey, I can verify that I gave this person these documents. So if you received a summons and complaint by finding them taped on your door or finding them in your mailbox, you have probably not been adequately served, which means you really have no obligation to file an answer to the complaint at that time. The problem is, I would still say in most cases, you still want to file an answer or at least reach out to the attorney who filed the lawsuit and have them properly serve you. The reason for that is this. It's very common for debt collectors, and it's wrong of them to do this, but it does happen, so you need to be aware of it. They will just mail it, or they will just have someone tape it to your door. And then they go to the court and they say, hey, this person has been served. So please, and they did not answer within the required time frame, usually around 21 to 30 days. And they will say to the court, since they didn't answer, please enter default judgment against them. And then boom, you've got a judgment. So even if you are not properly served, for example, they tape it on your door or they leave it in your mailbox, you still run the risk of a default judgment because the debt collector, wrongly, is going to tell the court that you have been served. So if you do get a summons and complaint by having it taped to your door or in your mailbox or whatever, then you still may very well consider filing an answer. And you think, well, I haven't been validly served. Shouldn't they have to do that? Well, sure, you can contact them and say, hey, you need to properly serve me. Or you can go to the court and file something, a motion to dismiss, something like that, that says, hey, they didn't serve me, you should throw this case out. The problem is it's so easy for them to fix that error. So if you go to the court and say, hey, they didn't serve me, you can't grant judgment against me, the court's going to say, well, yeah, that's right, and then the debt collector serves you right there in the courtroom. So there's really not a lot of advantages to that. Now, I'm not saying don't do that at all. You absolutely can fight it by filing a motion to dismiss or ignoring it. You just need to be careful, because they will use your failure to respond against you, even though they shouldn't. Now, if that has happened to you, you're just going to turn around and file a motion to set aside the judgment. And you're going to say, hey, I was never served. I found this document taped to my door. I found this document in my mailbox, or I never got this document, whatever. So, if you get a judgment granted against you, there are ways to get out of that if you haven't been properly served. So, it's not a huge worry. But again, you just want to think about the fight that you're going to have with the debt collector is not necessarily always over service, because it's something that they can easily fix when you point it out. Now, another question I get about service a lot is, well, they left it with my roommate, or they left it with my spouse. In most states, as long as there is an adult at your house that accepts a copy of it, then the court is going to consider that adequate service. And again, the court is concerned about, did this person get notice of the lawsuit? They're not necessarily always worried about the technicalities of it, but it's just, we want to make sure that they get notice. So, if the process server comes and gives it to your spouse, there are two people that the court could call in if necessary to verify, that service was given, or that, you were given notice of the lawsuit. That can be a little tricky with roommates, I suppose, if you're not close with them, or they don't like you or whatever, and they get it and don't give it to you. I definitely have people reach out to me and say, oh, my roommate got the summons for me but never gave it to me. And that's a problem, because that probably is adequate service as long as it is an adult living in your household. It probably is adequate service. Now, the other question is, well, what if they leave it with your kid? What if they leave it with your teenager? Maybe a 16-year-old. In most states, that's not going to be valid service. But again, you need to be careful, because the process server is going to go to court and say, yeah, I served this person. Maybe they don't know the teenager isn't an adult. Maybe they assume that they are. They aren't, so it isn't technically service. But if you ignore it, you do so sort of at your own peril. Now, when you do get service of a summons and complaint, the absolute most important thing to do at that point is to file an answer. That is, you're responding to all of the allegations in that complaint by either admitting, denying, or saying that you don't know whether what they're saying is true or not. If you need help filing an answer, we've got forms at debtbrief.com. You can buy the basic forms package. It comes with an answer and an instruction ebook telling you how to fill out that answer. And not only that, we've given you 9 other forms that will help you know what to do after you file that answer, because that's, again, another thing that I see a lot of people make mistake on. They're like, okay, I got served, I filed an answer, they don't know what to do next, and then they end up with the default or summary judgment anyway, because, well, they thought they filed their answer. That's all they needed to do until the court date, and that's not true. So our basic forms package, it will give you all the forms that you need to take this case all the way through to trial. And again, if you need even more help than that, I am available for consultations. You can sign up for that right on the website debtbrief.com. So good luck fighting your debt collectors. Again, check out your state's rules of civil procedure on valid summons and service, and I hope you beat them.